Hi everyone, I am Navya from D3. Today I am going to discuss the topic UAPA, that is Unlawful Activities Prevention Act. Before going to this topic, first we should know why is it in news. It is being used frequently because of various reasons and because of various issues. Recently, the Ministry of Home Affairs decided to declare a separate political organization in Punjab, that is where is Punjab D, an organization as a banned organization and as a terrorist organization under the stringent provisions of UAPA. And there were also serious allegations on the pro-Khalistan activist, that is Amritpal Singh, as a terrorist. So it is in news. And it was been recently amended in 2019, so it is in news. So in this session, we will discuss about UAPA in detail and also we will discuss in a main censor perspective. So in this session, we will discuss about its evolution and its objectives and provisions of UAPA Act and provisions of the amendment of UAPA Act and the challenges of UAPA and the measures to overcome the challenges in order to proper and active implementation of the UAPA. First, we will discuss about its evolution. In India, passing any anti-terror legislation is being a debate because the regulations in those acts curtails the freedoms, rights, liberties of the individuals which was guaranteed by the Part 3 of the Constitution. So earlier there were also laws, but the laws were passed only for a brief period until the situation gets better. But as days goes on, the terrorist activities has been increasing tremendously. So there is a necessity for a stringent law to be passed to combat terrorism. Hence, UAPA and NSA came into the picture. So, UAPA and NSA Act are the laws now in effect in India to combat terrorism. So, now we will discuss about UAPA in detail. It was enacted in the year 1967 after Naxalbari incident and after domestic issues like demanding a separate Tamilian country for the Tamilians. So, these issues has been increased in India over a certain period of time. Then there is a necessity for implementation of a law, hence UAPA came into picture in 1967. And it has been amended many times, that is in 2004, 2008, 2012 and 2019. The first amendment of UAPA was done in 2004 after the repeal of POTA Act. So here we should know about TADA and POTA Acts which were passed earlier to the UAPA. TADA and POTA Act. TADA is Terrorist and Disruptives Prevention Act, that is passed in the year 1987. And it was passed in 1987 after Punjab terrorist activities. But it has been misused, which can be evident in the case Kartar Singh versus State of Punjab. It was been misused, which can be evident in the Kartar Singh versus State of Punjab case, and it was the primary legislation which deals with the terrorist activities in India. But after implementation of this law, there is abuse of power and even the enforcement authorities use it to begin to exploit the strict guidelines of the law. Hence, it was repealed in the year 1995. Now it was repealed. So there is no law in India to combat terrorism. Again, the cross-border terrorism has increased. There were parliamentary attacks and there were many hijacks. So there is a need for another law to combat terrorism. Hence, POTA came into picture. POTA is Prevention of Terrorist Activities in India. It was passed in the year 2002. And similar to TADA, how it was misused, POTA was also misused, which can be seen in the case PUCL versus Union of India case. And there were also serious allegations that after the implementation of POTA Act, there was increase in the corruption in Indian judicial and police officials. Hence, it was also repealed in the year 2004. In the year 2004, POTA was repealed and UAPA was amended. But the provisions of POTA Act, which was repealed, were added in the UAPA Amendment Act 2004. And the second amendment of UAPA was done in the year 2008. And it was done after the terror attacks of Mumbai. And in the same year, the government also enacted the National Investigation Agency Act 2008. And in the year 2012, the third amendment of UAPA has taken place, and it was amended to incorporate economic and financial offences relating to terrorism. And it was also enacted to curb the international financing of terrorism within India. And in the year 2012, a new change came. That is, previously the government banned an organization for a period of 2 years. But here the period extended from 2 years to 5 years. That is, an organization is banned for a minimum of 5 years. And recently in 2019, UAPA was amended, and there were some provisions which were amended, which we will discuss later in detail. So this is about evolution. Now we will discuss about its objectives. Any anti-terror legislation in India was passed to combat terrorism. So similarly, UAPA Act was also enacted in order to prevent the unlawful activities. What is meant by unlawful activities? That is, the activities which threatens the integrity and sovereignty of the India are known as unlawful activities. So UAPA also deals with the activities which are directed against integrity and sovereignty of the India. Next, NIA. It is National Investigation Agency. It is the main law enforcement agency in India, which was established under National Investigation Act 2008. It is about evolution and objectives. Next, we will discuss provisions. But before going to the provisions, we will see some of the statistics of UAPA. Here, the first graph shows the UAPA cases from 2014 to 2019. Here, this indicates the cases pending from previous year, and this indicates the cases that brought in that year. If we see that, for example, in 2014, there are approximately 3000 cases, but in that 3000 cases, approximately 2000 cases were the cases that were pending from the previous year, and only 1000 cases were the cases from that year, filed in that year. And it was in the same case in every year. And for example, if we see in 2018 also, there are approximately 5000 cases, and there were approximately 4000 cases which are pending. That is, approximately 4000 cases which are pending from the previous year, and only 1000 cases that were filed in that year. Hence, we can say that the percentage of pendency rate in UAPA cases was very high. And if we see in the next graph, that is conviction rate. So before going to this graph, first we should know what is meant by conviction. That is, it is an official declaration of the judiciary that is someone is guilty of the crime or not. That means if you done the crime or not. So here the conviction rate of UAPA is very less, that is approximately only 2%. Compared to IPC, UAPA conviction rate is very less. And according to NCRB data, approximately 95.4% of the people who were arrested under UAPA are awaiting for the trials. Hence, we can say that the conviction rate is very less in UAPA. Next, we will discuss the provisions of UAPA, which is very important. And here, the central government has the power to designate an organization as a terrorist organization on the grounds that if he commits, participates, involves, or promotes any terrorism, then the government will declare an organization or a members of the organization as terrorists. Here, both Indians and foreigners can also be declared as terrorists. And under UAPA, it is applicable even if the offence is committed outside India also. And there is a special court which will conduct trials under UAPA. And the highest punishments in UAPA is death and life imprisonments. And the charge sheet is of maximum 180 days. It means you should be in judicial custody of minimum 180 days. That is, one individual should be in jail without bail for a minimum of 6 months. Without bail under UAPA. And under UAPA, to seize properties, the investigation officer should need the prior approval of DGP, that is Director General of Police. And the investigation is done by DSP or ACP or the officers of above rank. Here the treaties regarding UAPA are Convention for Suppression of Terrorist Bombings, Convention Against Taking of Hostages. Here the first treaty It is a UN law treaty in which terrorist bombings are treated as unlawful activities. And the second treaty is also UN law treaty in which states prohibit hostages. This is about the provisions of UAPA. Now we will discuss the UAPA Amendment Act 2018, which is very important. And it was done on the recommendations of the Committee of National Integration and Regionalism. And here you should know the difference between the Amendment Act and the previous act. Here the government can designate the individuals also on the same grounds, that is, who commits, participates or involves or promotes terrorism. Earlier, the government has the right to designate only organizations or the members of the organizations as a terrorist. But here it is not the case. Here it can also declare individuals can also be terrorists. Here there were no changes in bail and arrest. And it was amended to facilitate the speedy investigation. Here, to seize properties, the investigation officer should need the prior approval of Director General of National Investigation Agency. Here, the investigation is done by the officers of NIA or rank of inspector or above. But whereas earlier, to seize properties, prior approval of DGP is needed, but here the prior approval of Director General of National Investigation Agency is needed. Whereas earlier, the investigation is done by DSP or ACP or the officials of above rank. Here, the investigation is done by officers of NIA or inspector. In the UAPA Amendment Act, another treaty was added, that is International Convention for Suppression of Acts of Nuclear Terrorism. It is also an international treaty which curbs nuclear terrorism. This is about provisions of UAPA. Now we will discuss about the challenges of UAPA. Challenges of UAPA. It is in use frequently because of the misuse of UAPA. There are many challenges of UAPA like judicial challenges, constitutional challenges, legislative challenges, ethical challenges, economic challenges. Judicial, constitutional, legislative, economic, ethical. Now we will discuss these challenges in detail. First, misuse. As we discussed earlier, like POTA and TADA, that is POTA in Kartar Singh case versus State of Punjab and TADA in PUCL versus Union of India. In those cases, how those legislations were misused, in the similar way, UAPA was also being misused. That can be evident in this data, that is, according to the Home Ministry, 53% people were arrested in the years 2018, 19, 20 were below 30 years and they were belong to UP, Jammu Kashmir and Manipur. As it is in the map, here we can see the number of persons arrested under UAPA are highest in UP and Jammu Kashmir, followed by Manipur. So hence we can say that Manipur, Jammu Kashmir and UAPA accounts for total 70% of the total arrests in 2020. So we can say that UAPA was being misused. Now we will discuss about judicial challenges. That is low conviction rate. As we discussed earlier in this graph, conviction rate of UAPA is very less, that is approximately 2%. According to NCRB data, 97.5% of the people who were arrested under UAPA were still under trials. So this is one of the judicial challenge. And the second one is denial of bail. That is, according to section 43D5 of UAPA, according to section 43D5 of UAPA, a person can be arrested and a person cannot be granted bail if the court opined that there are reasonable grounds to arrest him. That is, but it violates the Article 21 of the individual. And in the famous case, that is Zahur Ahmad Shah Watali case, the Supreme Court said that every allegation that is made in FIR need to be correct. That is, the bail must be obtained if the accused should provide anything. That is, the total burden rests on the individual, that is accused, to disprove the allegations, which is virtually impossible. So here under UAPA, without trails, the bail may not be possible. But this violates the rights, freedoms, liberties of the individual, which is enshrined in the Constitution in the Article 21. These are judicial challenges. Now we will discuss about the constitutional challenges. Our Constitution granted some of the rights, liberties and freedoms to the individuals, that is under Article 14, 19 and 21. Right to equality, right to freedom and right to life and liberty. But here under UAPA, they are identifying the individual as a terrorist, that is without judicial scrutiny and before the commencement of trials, without evidence, an individual is declared as a terrorist. So it is violating our rights. It can be evident in the cases like Sajal Ashwati versus Union of India and Association for Protection of Civil Rights versus Union of India. In both of the cases, the individual's rights and liberties has been curtailed. This is one of the constitutional challenge. Next, second constitutional challenge is federalism. As we know that under Schedule 7, police comes under state subject. But under UAPA, the investigation is done by the National Investigation Officer. Here, the encroachment of state jurisdiction has been happening. Actually, it should be done by the police, but it was done by the NIA. So, here it violates the principle of federalism. These were the constitutional challenges. Now, legislative challenges, that is, the UAPA Act itself has some flaws. That is, there is no concrete definition of terrorist. Means who is terrorist and who is not, on what basis they are declared as terrorist, on which criteria they are declared as terrorist, it was not defined. So there was no concrete definition of terrorist, it was been misusing a lot. And UAPA contravenes Universal Declaration of Human Rights as well as International Covenant on Civil and Political Rights. So now you should know the difference between those two. Universal Declaration of Human Rights and International Covenant on Civil and Political Rights. Here, UAPA contravenes Universal Declaration of Human Rights as well as International Covenant on Civil and Political Rights. So now you should know the difference between those two. Universal Declaration of Human Rights and International Covenant on Civil and Political Rights. It is an international document adopted by United Nations General Assembly which enshrines the individual's rights, liberties and freedoms. It was not legally binding. Though it was not legally binding, it was incorporated in many nations' constitutions and it was incorporated in many treaties. Whereas ICCPR is also a treaty in which our individuals' freedoms, rights, liberties were identified, and it will also include the right to life and right to liberty and right to fair trials, which is very important. Here this aspect is been violated by UAPA. And the difference between UDHR and ICCPR is more comprehensive than UDHR. That is, it tells about individuals' rights, liberties and freedoms in a comprehensive way. UDHR is not legally binding, whereas ICCPR is legally binding on the signatories. Here is the difference between those two. Now, these were the judicial challenges, these were the constitutional challenges and legislative challenges we discussed. The process becoming a punishment, that is, according to NCRB report, 40.5% of the cases were sent for trials, but only 4.5% are completed. So, nearly 8 to 12 years is been wasting. These were the legislative, judicial and constitutional issues. Now we will discuss about economic and ethical issues. First, economic issues. The individual these many days in jail is a loss of employment to him, and also it can affect on his family economically. And India can also lose its human capital. And there were also ethical issues, which we discussed earlier were also come under ethical issues. Those UAPA violates our rights, liberties and freedom. And another ethical issue is If he is a terrorist, if he is in jail, there is no problem. But if he is an innocent, if he is in jail for that many years, that is 8 to 12 years, these many years can change an individual, that is an innocent individual, into a terrorist, which can threaten the nation. So itself is another problem. And these many years in jail can also affects his or her family, her children emotionally, etc. These were the ethical issues in UAPA. Now we will discuss the measures, that is way forward. Before going to this way forward, here are some of the banned terrorist organizations in India, that is Al-Qaeda, CPI, etc. Now way forward, as we discussed challenges, we should suggest some measures to each challenge. That is, as we discussed earlier, there is misuse, so checking of misuse is needed, and the trials were very late, so speedy trials is needed, and judicial scrutiny is needed. That is, an individual after judicial scrutiny and after proper evidence should only, after those only he should be treated as a terrorist. And broadening the definition of the terrorist is also needed. Here, as we see here, the Amendment Bill 2019, it is a complete picture of what we discussed till now. That is, here the original act, that as we discussed the aims of UAPA Act and the amendments and reasonable restrictions, that is Article 19, freedom of speech and expression, right to assemble peacefully, right to form associations, and it was passed in Lok Sabha, and the changes made as we discussed earlier, and the reasons for the UAPA Amendment Bill, and the concerns, that is the challenges which we discussed, that is no limited justice, no transparency, accountability, individual freedom and liberty, and it is also a way forward, that is definition of terrorism is needed, accountability, transparency, etc. This is the complete picture of what we discussed till now. This is about UAPA. Now we will discuss mains question, that is UAPA is the India's main anti-terrorism legislation, but UAPA is being grossly misused, often with impunity. Discuss. Here in order to answer the mains question, you should also integrate some of the additional points which will fetch you more marks. That is, here they asked how you should write the significance of UAPA and how it is combating the terrorism in India, and you should add some graphs as we discussed earlier, and some data based on NCRB report, Ministry of Home Affairs, etc. And you should show some map, and you should write in this way, and it has been grossly misused. That is, you should write the challenges, means how UAPA is being misused, means you should write the challenges of UAPA, and if or if not mentioned in the question, you must suggest some measures in order to overcome the challenges. Measures to overcome the challenges. This is a way to write the mains question. And finally, UAPA Act, repealing the act is not a solution because it can increase the terrorism. Whereas following a similar manner is also not a solution because it can curtail our rights, freedoms and liberties. So individuals' liberties are at stake. So repealing is not a solution, as well as following in the similar manner is not a solution. So UAPA should be there, and the stringent clause should be there to combat terrorism. On one hand, it should combat terrorism, and on other hand, it should protect the rights, liberties and individuals. So UAPA should be there, and there should be certain measures in order to proper and active implementation of UAPA. Thank you.